let's go ahead and start. Let's put those away. If you weren't here last time, I handed back papers, so I might have yours if you want to grab it from me after class. The next paper is due on Monday, right? It is paper assignment 3A, the first half of paper assignment number 3, which is approximately 4-page partial draft of what will eventually be a 10-page paper. The full detailed prompt is on the syllabus, but the gist of it is to write about some way in which the Constitution has changed during your lifetime. Questions about that assignment? A couple people have come to see me. I've got office hours right after class today, 11 to 12, if anybody needs to see me. And a couple people came to see me on Tuesday. So I don't want to suggest there's any one cookie-cutter version of the paper, because there's not, but here is just a little bit of a template, if you haven't gotten started yet, of what to try to do by Monday. You're not writing the full paper, right? So you don't have to have all the research completed, but you have to have a sense of what you're writing about. You need a topic, for sure, and you need to be working towards some kind of argument about what you want to say about that topic. So tell me a provision of the Constitution, right? Identify some particular part of the Constitution and tell me something about how that provision of the Constitution was understood at some prior point in time before you were born, and tell me something about how that provision of the Constitution is understood today, right? And then you have then identified some constitutional change, and then for purposes of Monday, get started on telling the story of how that change took place, right? Well, how did we get from A to B? Why do we have a different understanding of this part of the Constitution now than we did before, right? And the prompt says you have to describe that change. You have to try to explain that change, like why did it happen? Why did our understanding of this part of the Constitution shift? And you have to evaluate that change, right? Is it changing in a good, positive direction, or is it changing for the worse, or is it some combination? Right? So that's what you want to try to do. There's lots of possible topics. Right? I've been using this prompt for a number of years now, and the time period shifts 1 year at a time each year, right? You guys are always approximately 20 years old, but the 20-year period moves forward a little bit every year. But I can tell you some of the topics that I have gotten lots of good papers on in recent years. These are not the only possible topics, but they are some good ones. Some of the major constitutional developments that have occurred in your lifetime have included the following topics. The Constitution's relationship to the electoral process, right? Bush versus Gore was a decision involving the 2000 election 18 years ago. That's a case we'll talk about. There are cases on the Supreme Court's docket this year that are about election law, right? About gerrymandering and the like. So drawing some connections between those things, that's one good topic. The Second Amendment, right to bear arms. There have been 2 major landmark Supreme Court decisions during your lifetime that have significantly changed the understanding of the Second Amendment. That's another good topic I've gotten lots of good papers about. Marriage equality, right? Supreme Court has issued some landmark decisions on LGBT rights in general, and specifically about marriage equality during your lifetimes. The court, the main question of marriage equality is marriage equality constitutional right nationwide. The court said yes. The court already decided that one, but then there are still additional follow-up questions that are still on the court's docket this year, right? The case about the baker, right? Whether a privately owned bakery can be compelled to provide a cake for a same-sex wedding, or whether the private owner of the bakery can choose to provide cakes for opposite-sex weddings but not same-sex weddings. the topic that we covered last time, executive power, right? Presidential power. Major issue on which lots of things have happened, and there have been some notable changes during your lifetimes, right? 9/11, terrorist attacks seem to have led to a number of notable developments regarding presidential power and national security. And the topic that we're going to talk about today, and continuing into next week, about the limits of federal power in our system of federalism, is another topic I've gotten a lot of good papers about in recent years. Next week, we are going to talk about the Supreme Court's decision involving the Affordable Care Act, right, also known as Obamacare. So the law was enacted in 2010, and the Supreme Court decision upholding most of it was a couple years later, 2012, 2013, 2012. So we'll look at that case next week. That, I have to say, is probably the single most, just in terms of like contemporary political focus. The Supreme Court's decision about Obamacare was the single most closely watched Supreme Court decision of your lifetimes. Maybe Bush versus Gore too, right? That's a close call. One of them decided the outcome of a presidential election. One of them decided the fate of the most significant piece of domestic policy that had been enacted in 40 years or something. And there was lots and lots and lots and lots of attention to them, right? So you're not writing a paper about one case, but one case can be a starting point, right? And our topic for today, we're not talking about Obamacare today, but we are talking about some cases prior to the Obamacare case that address basically the same constitutional questions. And so when we get to Obamacare next week, to understand how the different justices were approaching the constitutionality of the Affordable Care Act, right, you have to have some sense of what they thought about this kind of constitutional question prior to that as well. So we're kind of laying the groundwork for that discussion today. Questions about the paper? Okay, come see me if you got questions. Okay, so for the last few classes we've been talking about, the general topic has been the division of powers between Congress and the President, right? So last time we were talking about it in the national security context, and before spring break we were talking about it in the domestic context, things like immigration law, right, where Congress will say, the Attorney General can halt a deportation, but then Congress can overrule the Attorney General's judgment in a particular case if it wants, right? Is that legitimate or not? How does the balance of power between those two branches work? And then the same thing last time in the national security context. What is the President allowed to do on his own? What does he need congressional authorization for? And the like. So today, and next time, we're talking about the division of power between the federal government and the states, right? So these are often referred to as horizontal and vertical divisions of power, right? James Madison in the Federalist Papers talked about both of them and said, we are creating, in our constitutional system we have designed, we are creating a double security for the rights of the people because we have divided up governmental power along two different dimensions. Right? Some powers left with the states, some powers with the national government. Even within the national government, the power is divided up horizontally. All these divisions of power are going to make it harder for anybody to act tyrannically because nobody has all the power. Right? That's the idea from the beginning. Double security for the rights of the people. But of course, if you divide up governmental power among lots of hands, it makes it harder for the government to get anything done. Right? Which is a potential downside. And it also creates the potential for significant conflict between different parts of the government about who has the authority to do something. Well, no, the states can do this. No, the federal government gets to do this. No, we're arguing now. Somebody's got to decide. Right? So on both the horizontal division and the vertical division, we've got a long history of conflicts. So jump back for a second to Con Law 1. Those of you who took Con Law 1. Bring your minds back to two cases from Con Law 1. One from way back at the beginning, McCulloch versus Maryland in 1819. and another one from towards the end of the semester, Wickard versus Filburn from 1942. What was McCulloch about? I'm going to test y'all's recollection from last fall. McCulloch versus Maryland in 1819. Yeah.
Was that the one about the bank?
Yep.
So they were, Maryland was trying to have their own, I think McCulloch was the Attorney General at the time.
He was an officer at the National Bank of the United States.
And Maryland was trying to incorporate their own bank, and then tax the federal government through that bank, and the court said that you couldn't do that.
And what was Congress trying to do? What was the federal government trying to do?
The federal government was trying to expand their powers.
Yeah.
They're trying to,
Why? Like, what were they trying to accomplish?
Well, they said that it would get, they would absolve all the colonies' debts, right, in that one, because, so they could, wipe the debts away, but then after that, there's still going to be, then the colonies would have to.
You're on the right track. Yeah, so they're not colonies anymore; they're states now, right? But it's part of under the new Constitution, George Washington's the first president. He appoints Alexander Hamilton Secretary of the Treasury. Hamilton has this whole broad, ambitious economic program for the new federal government to pursue. Part of which is about the federal government is going to assume all the debts that the state governments have incurred in fighting the Revolutionary War. Several of the states were deeply in debt as a result of the Revolutionary War because they were trying to raise their militia and pay their soldiers and get them uniforms and everything. And the federal government should take over all those debts, right? We fought this war as a nation, as a country, all together to win our freedom. The individual states shouldn't be responsible for handling those payments. The federal government's going to take that over, which means the federal government's going to need a stable source of revenue. So Hamilton was big on pushing for federal tariffs to be imposed. We're going to tax imports. That's going to be our main source of revenue. And we also need a stable financial system. And Hamilton's plan on that front is we are going to create a nationally chartered bank called the Bank of the United States, which is given its marching orders. It's sort of a public-private complicated thing, right? It's a private bank, but it's chartered by the federal government, and it's going to play some roles in federal monetary policy, like federal government deposits, for example, will be deposited in this bank. And it's going to have branches all throughout the country, which is going to help us make it easier to move cash from one place to another for the federal government to spend money. And so Hamilton thinks it's a great idea. He persuades Washington on it. He persuades the Congress. They enact the bill. They charter it. And then Maryland says, we don't want this bank operating in our state. We got our own state chartered banks. And so we are going to impose hefty taxes on the operations of the national bank. And so this is now a conflict between the state of Maryland and the federal government, which the Supreme Court has to resolve. And Maryland's lawyer argues that the national bank bill passed by Congress was unconstitutional. Why do they think it was unconstitutional? Why does Maryland think that Congress's chartering of a national bank is unconstitutional? Right? There's nothing in the Constitution that says Congress can charter a bank, right? Article 1, Section 8 of the Constitution lists the powers of Congress, and none of them say explicitly Congress can charter a bank. Or, if you want to make that a little more broad, none of them say explicitly Congress can issue charters of incorporation for any kind of private company, right? States usually have been doing that. Nothing says Congress can do it. So Congress can't do it, is Maryland's argument. Maryland loses. Why does the Supreme Court uphold the bank? Jack?
They come to the decision that the Constitution might not have included all explicit examples of constitutional power, but I think it was the necessary and proper
Mm-hmm.
clause of the congressional powers in the Constitution that allowed for this bank to exist to enable the government to do other things with the money.
That's right. Right. No, there's nothing in there that explicitly says Congress can charter a bank, but there's a whole bunch of specific things in there that have something to do with regulating the economy and providing a stable monetary system, right? And the powers need, and then at the end of the list it says Congress has all powers necessary and proper to carrying into execution the foregoing powers. And we got to read those things broadly, especially the one at the end, but really we got to read all of them broadly in order that Congress can successfully tackle national problems, some of which will be new and unanticipated. Right? This is a constitution we are expounding, a constitution intended to endure for ages to come, right? And hence to be adapted to the various crises that, of human affairs that emerge over time, right? Famous quotes from Chief Justice Marshall about we have to interpret federal powers broadly. That's in 1819. Okay, jump forward more than 100 years, Wickard versus Filburn in 1942. This is the one about the wheat farmer. What's going on in that one?
That Commerce Clause, he's growing wheat, but only for his own use.
Mm-hmm.
And the government says that that's still under Commerce Clause, even though it's not, has nothing to do with interstate commerce.
Yep, and the government wins.
Yeah.
Why?
Because his actions still affect the actions of others engaged in the trade.
Basically the same deal. It's a different kind of case. The specifics are detailed. But the specifics are different, specific details are different, but the court is again adopting a broad understanding of federal powers, right? Congress is regulating the wheat market because we are in the midst of the Great Depression and the wheat market, like the rest of our markets, has completely fallen apart, right? Farmers are going out of business because the price of the demand for wheat has gone way down because nobody has any money, and so the price of wheat has gone way down, and so even when farmers are selling some wheat, they cannot recover their costs. Right, the market has collapsed. And so Congress is passing a broad regulatory scheme to try to improve the health of the market and stabilize it, which means we need to prop up the price, which means we need to reduce the supply, right? And so in order to reduce the supply of wheat, we are going to give every wheat farmer in the country an allotment. And we are going to offer them some subsidies, right? You're not allowed to grow as much wheat, you can't sell as much, but we're going to give you some government subsidies. And there's a carrot and there's a stick. If you grow more than you are allowed to grow, we are going to fine you, right? This guy grows more than he's allowed to grow, and he gets fined by the government. But his lawyer says, "Come on, federal government's not even allowed to regulate my production of wheat because I am not selling it. I am for sure not selling it across state lines. In fact, I'm not selling it at all. I am feeding it to my own cows. I am a dairy farmer, not a wheat farmer, but I grow some wheat on my farm for use on my own farm. I am not engaged in interstate commerce, and so the federal government should not have the power to regulate my production of wheat." And he loses unanimously. Both these cases are unanimous. He loses unanimously. The Supreme Court's like, yeah, all right, whatever. If you look at it really narrowly and technically and specifically, this one guy is not engaged in interstate commerce. But he is, if you aggregate together all of the different farmers in his position, right, you're talking about a lot of wheat, right? And if they're growing it themselves, that means they're not buying it from somebody else. And so they are part of the wheat market, which is an interstate market, which Congress clearly has the authority to regulate. Any activity that is part of interstate commerce or that has some substantial effect on interstate commerce, the federal government is authorized to regulate. That is a broad it's plausible, but it's broad interpretation of federal powers. Right? From Wickard versus Filburn on forward, for several more decades, the court continues to rely on this broad interpretation of federal powers. The Commerce Clause is the most significant power. The necessary and proper clause is also really significant. There's other powers on the list too in Article 1, Section 8. Just the one that comes up the most often are commerce and necessary and proper. We talked about one of these examples already this semester, which was the case is about the 1964 Civil Rights Act. Right? Remember Heart of Atlanta Motel versus McClung? Supreme Court says 1964 Civil Rights Act prohibits racial discrimination in employment and in public accommodations. Right? So hotels and restaurants can't refuse service on the grounds of race. Even locally owned barbecue joints down in the South that are not very much engaged in interstate commerce, this law still applies to them. Congress's power is broad. Anything that has some substantial effect on interstate commerce, Congress is allowed to regulate it. In the 1990s, the court starts to change its mind or have second thoughts, maybe, right? Starts to wonder if it has gone too far in this broad interpretation of federal power. Two cases I'm mostly going to focus this on. One's from 1995 and one's from 2000. The first one's about a gun control law, and the second one's about regulations of rape and sexual assault. So they are both criminal law matters, basically. Congress passed a law in the late 80s, early 90s, called the Gun-Free School Zones Act. The Gun-Free School Zones Act made it a federal crime to be in possession of a firearm within 1,000 feet of a school. Right? Firearm possession is mostly regulated by the states, although there are some, throughout the 20th, since like the early 20th century, there have been some federal firearms laws, but it's mostly regulated by the states. But Congress says it's a national problem of gun violence, and this is a modest effort to do something about it. If you get caught with a gun in or near a school, it's a federal felony, and you can be prosecuted in federal court, and maybe we can impose longer sentences on you if the states aren't doing good enough job on this or whatever. And Congress says it has the authority to pass this law under the Interstate Commerce Clause. And the Supreme Court strikes it down. During the oral arguments in this case, it's called U.S. versus Lopez, the Solicitor General of the United States. So the law was enacted when George Bush, the first George Bush, was president. He's the one who signed the law. But by the time the case came to the Supreme Court, Clinton was president, so it was Clinton's Solicitor General. And the court, Chief Justice Rehnquist, in oral arguments said, can you give me an example of a federal law that Congress would not be allowed to pass under the Commerce Clause? And the Solicitor General stumbled and couldn't come up with anything, which maybe is just like a bad day, right, for the lawyer in the court that day, right? He didn't have a good example in mind, but for the court, it kind of seemed like a bad sign, right? If the federal government's lawyer cannot think of an example of a law that the federal government is not allowed to pass, right? Not because it violates the First Amendment or Bill of Rights or something, but a law that exceeds the scope of the Commerce Clause. It seems to me, if you're Chief Justice Rehnquist, it seems to me that the federal government is claiming it's allowed to pass any kind of law that it wants. This law does not seem to have anything to do with interstate commerce. Does it? Right? Doesn't seem like it. It's a regulation of gun possession in or near schools. How is that a regulation of interstate commerce? Seems to me that the government is saying it's allowed to regulate anything it wants. It has expanded the scope of the Interstate Commerce Clause so far, and we have let it, right? The Supreme Court has been part of this. We have let it expand it. It has expanded the scope of the Interstate Commerce Clause so far that it's allowed to regulate anything it wants. And the court says that's wrong. That's not what our original Constitution meant. We're going to strike it down. Now, the Solicitor General was in a tough spot. It's a hard question because the Solicitor General's job, right, he's the federal government's chief lawyer in the Supreme Court. His job, much of the time, in many of the cases that come to the Supreme Court, is to defend the constitutionality of federal law. Right? Somebody challenges federal law as unconstitutional, it's the Solicitor General's job to defend it, and so he's defending the gun law, and in some future case next year or the year after that or the year after that, he's going to have to defend some other laws. So he doesn't want to say in court, oh yeah, if Congress passes a law about X, that one would be no good. Because like if Congress does pass that law, then it's going to be his job in court to defend it, right? So it is a tough question for him. But he did not come up with any examples. And that seems to have influenced the court. Right? They're like, well, wait. I thought we had a federal government of enumerated powers where there are some things the federal government is allowed to do and some things that it is not allowed to do. And yet the government's lawyer can't think of anything that it is not allowed to do. Right? It sounds like something has gone wrong. Right? And so we need to start trimming the scope of federal regulatory power under the Commerce Clause. Does that make sense? If you are the Solicitor General, and your job is to defend this law, keep bearing in mind what we just said about McCulloch versus Maryland and Wickard versus Filburn. What is your argument? What is your argument in support of the constitutionality of the Gun-Free School Zones Act? Yep.
If you look at it wider, you would say probably along the lines of students partake in the transactions involving commerce, and they can't do that properly when they're worried about their lives.
That is exactly what he said. That's one key part of the Solicitor General's argument. Gun violence in schools harms our effort to educate students who are then supposed to participate in interstate commerce, right? How are they going to go on to have successful careers if they cannot survive school?
I think also just protecting lives in general could be an interest of the federal government, and they're just doing it on school property because it's federal property, and I guess it could also be justified on
Although it's not,
other federal property.
it's not federal property though, because schools are local.
Well, do
right?
they receive federal funding?
They do receive federal funding,
Then
so maybe that's the hook. Yeah.
Oh, can you just say because like parts of guns are made and manufactured in other states?
That's another part of their argument. The vast majority of firearms cross state lines, right? Like, the gun is not manufactured, sold, purchased, and shot in the same state, usually, right? So both the gun, the thing that is actually being regulated, that is usually part of interstate commerce, and the effects of the violence have an impact on, like, future interstate commerce, right? And if you think about the wheat farmer in 1942, it doesn't seem that different. He was not buying or selling any wheat. He was growing wheat on his own farm to feed to his own cows. But then he was milking the cows and selling the milk, right? So there's some connection, right? Congress's lawyers are like, well, it's just like the wheat farmer, right? Well, as long as we're interpreting Congress's powers broadly and flexibly, like you've said over and over again you're going to do, right? We think gun violence in schools has some significant impact on interstate commerce, and so we think we're allowed to regulate it. And the court says, no, that goes too far. Right? It's a 5-4 decision, right? So it's close. The dissenting justices all say all of these things, but the majority's like, no, that goes too far. Criminal law and education are both historically mostly regulated by the states. And this is a law that is about criminal law and about education. And so it's an effort by the federal government to step further into two realms that historically belong to the states. And if it were actually a regulation of interstate commerce, then we'd say, okay, the federal government is allowed to do that. But it doesn't seem like it's actually a regulation of interstate commerce to us. Court strikes it down. After this decision, Congress passes a revised Gun-Free School Zones Act that says it's a federal felony to possess a gun within 1,000 feet of a school if that gun has traveled in interstate commerce prior to your possessing it in a school zone, and the federal courts upheld that law. Right? That law only applies to articles that have been part of interstate commerce, so most firearms, right? But if you could prove, if your defense lawyer could prove in court that it was manufactured down the road, right, and you bought it at the store down the road, and it has never crossed state lines, then you could not be convicted under this law. But if the prosecutor could prove in court that, in fact, this gun was manufactured in Texas, and you brought it into a school in New York, right, then that law's good, the courts say, in a subsequent case. Right? Let me give you another example. In 1994, Congress enacted the Violence Against Women Act, which, as the title suggests, it's an effort to regulate violence against women, which is, again, a criminal law matter that is also regulated by the states. Right? Rape and sexual assault are illegal in every state under state law. But Congress says that this is a massive social problem that the states are not adequately responding to, right? And so we want to go further under our federal legislative powers. And one of the key provisions in this law said that, let me find the quote if I have it. All persons within the United States shall have the right to be free from crimes of violence motivated by gender. And it provided several specific legal provisions designed to achieve this goal. One of them said victims of gender-motivated crimes of violence can sue their attackers in federal court. Right? So in addition to any criminal prosecutions that might result, right, victims of rape and sexual assault can sue the perpetrators in federal court for damages. Right? That was one of the provisions of the law. And this law, it was enacted in 1994, which is the year before U.S. versus Lopez. But in 1994, when they were debating this law, U.S. versus Lopez was already working its way through the courts, and a lower federal court had already struck down the gun-free school zones law, which was weird at the time. Like, everybody's like, wait, I thought Congress's powers were really broad. They never strike down laws for going beyond the scope of the Commerce Clause, but a lower court had struck it down. So the lawyers who were watching, the federal government lawyers, were like, oh, wait a minute, looks like the federal courts are starting to pay more attention to this kind of argument in the Violence Against Women Act. Let's do a good job as we can to really document the connection between gender-motivated crimes of violence and interstate commerce. And so the federal government makes the same kind of arguments that we just articulated for the gun law, but they spend more time and effort on this, and Congress conducts hearings, and they introduce findings into the record that document the enormous scale of the problem nationally of gender-motivated crimes of violence. They document that many states are not adequately addressing the problem. And they document that gender-motivated crimes of violence have an extraordinarily significant effect on many women's abilities to participate freely in interstate commerce. Right? I mean, if you have to, move out of your house, leave, go live somewhere else in hiding to escape an abusive spouse or partner, right? I'm pretty sure you're messing up your career prospects, right? Your ability to engage in interstate commerce is harmed if you are a victim of gender-motivated crimes of violence, right? In substantial ways for lots and lots and lots of people, right? And it's well documented in the congressional record. In Lopez, in the gun case, they hadn't really paid that much attention to it because they didn't think they needed to, because the court never struck down laws for going too far under interstate commerce at the time, so they didn't think it was a problem. Now they knew it was a problem. The lawyers are on it, right? We're going to document it. And they got reams and reams of evidence purporting to show the connection between gender-motivated crimes of violence and interstate commerce, right? Rape and sexual assault are not themselves interstate commerce, but they are activities that have a substantial impact on interstate commerce. Court strikes it down anyway. 5-4 again. Right? And and the arguments are basically the same. 5-4, same justices in the majority, same justices in dissent. Rehnquist writes the majority opinion again. And there's two ways to think of these cases. One is so if you think of it as, this is not going to be exactly historically representative and accurate, right? But if you just think of it as change over time, right? What is the scope of the power of the federal government, right? Federal government has gotten bigger and more powerful over time, right? So you can think of it like this, right? It's probably not a smooth line like that over time, right? It's probably gone in some peaks and spikes, right? Maybe the New Deal, right? Those cases in the late 30s and early 1940s are a big spike where federal power really jumped a lot. But over time, in general, it has increased. So there are two ways to think about what is going on in these cases. One way to think about it is that the court is just trying to put some limits at the margins, right? Federal power has increased a lot, maybe too much. Let's just cut it off here, right? It's just gone a little too far, right? Right? Walking past a school with a handgun in your belt, that does not really sound like interstate commerce. Aren't the states perfectly capable of regulating that on their own? In the framers' understanding, does that have anything to do with the national government? Right? We've just gone a little too far. We're just going to cut it off here. That's one way to think about it. The other way to think about it, and there are some language in the opinions, especially in Clarence Thomas's concurring opinions in these cases, is we gone way too far and we need to go back. Right? We are not cutting it off here. We're cutting it off back here or here. Right? Somewhere way back. Right? Clarence Thomas says these laws are completely inconsistent with the original understanding of federal power, which is, I think, true. Right? The guys who wrote about federal power in the 18th century were not thinking about a national regulation of gender-motivated crimes of violence. That is not what they were thinking about. Right? It goes way beyond the scope of federal power. They thought criminal law would be handled almost entirely by the states. Thomas is we need to go back to the original version. That is the version in the constitutional text. That is what we need to try to go back to. Right? And so if that's right, then that means not just the Gun-Free School Zones Act and the Violence Against Women Act, but the 1964 Civil Rights Act and the Agricultural Adjustment Act from the New Deal, and the National Labor Relations Act from a different New Deal case, and the federal minimum wage law from a different New Deal case, right? All of those laws are probably unconstitutional, right? If you are trying to go back to the original version of congressional power, I mean, look how much congressional power has grown over the years. That's like a lot of backtracking we're going to have to do. There are a lot of Supreme Court decisions that are now going to be wrong, and we are going to have to reverse. And there are a lot of federal laws that are now going to be unconstitutional, and we are going to have to strike down. If that's what these cases mean. Questions so far? All right. So, I got a question for you. Find it. Does the federal government have constitutional authority to outlaw the possession of marijuana? Yes or no? Not what is your preferred answer. What do you think the actual legal answer is, and why? I see some tentative nods and head shakes in both directions. Somebody get us started. Yeah.
It's a fair and proper route to a certain goal that's authorized under the Constitution.
What's the goal?
I don't know exact words, but maybe exactly. But it seems like a logical step that they could take that would enable something.
All right, so that's a start, right? Necessary and proper clause is the broadest part of Congress's powers in Article 1, Section 8, but you still got to connect it to some necessary and proper to what in particular. So what else do we need? Jack?
Well, it's a major crop in some areas and could be very useful, and if legalized would definitely be like something that people sell across state lines, so it has something to do with interstate commerce, and I guess that also includes stopping the interstate commerce of something.
Even illegal activity can be interstate commerce, right? If you are buying and selling something across state lines, like millions of people buying and selling millions of pounds of it for millions of dollars across state lines, that sounds like interstate commerce, right? So, federal government can regulate it, can outlaw it altogether if they want, which is what the federal government currently does, or maybe can not outlaw it, right? Can say, oh, this is a commodity that can be bought and sold lawfully, and here's some regulations on that. Yes, the federal government could do that if it wants. Supposing I am growing marijuana in my closet, a small amount, for my own personal consumption, and I am not buying or selling it, can the federal government regulate that?
Isn't that what they decided that they could?
If Wickard versus Filburn is correct, then I think they can. What about, though, under Lopez and Morrison? Right, so Lopez is the gun-free school zones case. U.S. versus Morrison is the Violence Against Women Act case. Under Wickard versus Filburn, I think the answer is definite yes. I'm just like the wheat farmer, right? Homegrown weed or homegrown wheat, right? Same thing, right? Why would they be able to regulate one but not the other? But what about under Lopez and Morrison? Does that seem like it would change the answer? I'm good at waiting patiently. if you are the lawyer for the federal government, would you be worried about the federal marijuana laws in the wake of the Supreme Court's decisions regarding the gun law and the Violence Against Women Act?
Not necessarily, because I mean, these are a little bit more about like guns, and then the Violence Against Women Act are a little bit more about possession. But weed, like somebody mentioned, is sold and bought. And also, I don't know if they mentioned this, but like you can't just like take the plant itself and like smoke it. You have to have like other forms of paraphernalia, like rolling paper or a pipe, and you have to buy that and make that paper or that pipe cross interstate lines.
Yeah, but I could put it in a brownie, right?
But the brownie can also cross interstate lines.
Maybe so. Okay. Right. So there are obviously a variety of like related regulations that maybe the government could still make it harder for people to use marijuana. You're not allowed to buy chocolate if you're planning to, I don't know. There are a variety of other regulations that, we're not going to impose put regulations on bongs or rolling papers or whatever. Like, okay, that might work to help make it harder to use. But still, like, it is a plant that is capable of being grown on private property and then consumed, right? Which, again, under Wickard versus Filburn, it would seem like the government can definitely still regulate that, because it's, even if you are not selling it, right? Overall, if you aggregate together all the different people in your situation, right, we're talking about a lot of marijuana, right? And it's part of the overall national weed market, even if you yourself are not selling it. So under Wickard, the answer is definite yes. But under Lopez and Morrison, this court is trying to cut back on that. And I'm just trying to use this example to force us to sort of think through, like, how much do we think they're trying to cut it back? Like, do we think that would apply here or not? If you are a lawyer for somebody who gets arrested because the cops discover that she's got a couple plants in her closet and she had no plans to buy or sell them, she was just for home use, and this is after Lopez and Morrison, if you are that lawyer, what do you say? Like, what's the best argument you can make that the federal government can't regulate this?
I'm sorry, can I go back to Wickard real quick?
Mm-hmm.
If the government specifically outlaws and says there can be no interstate commerce of a product, then how can the personal use of a product ever affect interstate commerce? In Wickard, his personal use is affecting the overall market, but if there is, by law, no overall market, how can personal use affect that?
I mean, there's by law, the overall market is illegal, but it doesn't make it disappear. There is still a market, right? Everybody knows that there's still a multi-million-dollar marijuana market, right? Here's two key concepts from Wickard. In Wickard, and in a whole bunch of other cases in the 20th century, the court says that the language in the Constitution is that Congress has the power to regulate commerce among the several states, right? So that means commerce that crosses state lines. So anything that is actually being bought or sold across state lines, Congress can obviously regulate. But the court says it can also regulate anything that substantially affects interstate commerce. And so the logic there is that we have an increasingly integrated national, even global economy. And so there are things that at first glance might look like purely local economic activity, but they themselves have a substantial effect, right? So even though I'm just growing something in Syracuse and selling it to somebody in Syracuse, right, that is economic activity that is connected to broader interstate commerce, right? So like maybe like the Ollie's Barbecue down south, right? Most of my customers are local. My pigs are raised and slaughtered locally. But yes, it is true that like we're buying the napkins and the plastic forks and placemats and stuff from an out-of-state supplier, right? So we are involved in interstate commerce in some way, right? And the fact that we don't serve African Americans has an effect on interstate commerce in some way, right? So even local activity, even potentially non-commercial activity. I am not selling the wheat. I'm feeding it to my own cows. Is that still commercial activity? Because I'm selling the cow's milk, right? It's all connected, right? But even local non-commercial activity, if it substantially affects interstate commerce, can be regulated. Second thing from Wickard is that we're not going to look just at the facts of the particular guy's case, right? We decide one case at a time. There's some particular guy standing in front of us with his lawyer, right? But we're not just looking at him. We are looking at the overall scope of the regulatory scheme, right? So we're going to aggregate together all the other people like this guy who are affected by the regulation. And that's what we're looking at. Congress is not regulating one person's wheat farm at a time, right? Congress passes an overall scheme that has overall goals, and they're allowed to do that, right? And so we're going to look at it all aggregated together. Two key concepts from Wickard. If we're sticking to those two key concepts, then Congress can definitely regulate the private, non-commercial possession of marijuana, because there is clearly an interstate marijuana market, even though it's illegal. There's clearly a market, right? And if we aggregated together all the people who are growing their own in their own house and saying they're not going to sell it, right? That's an awful lot of additional weed that's unregulated that it's going to undermine the overall congressional regulatory scheme, right? Wait, there's hundreds and hundreds and hundreds of people all over the place legally growing weed, and yet we say that marijuana possession and sale is illegal, right? Aggregating them all together, that's going to have a huge and substantial effect. It's going to undermine the regulation. So if that is the governing precedent, Congress definitely has this power. But what I'm saying is, if Lopez and Morrison, which are more recent than Wickard, right, they didn't overturn Wickard. They didn't say Wickard was wrong and we're overturning that. But they do seem to be going in a different direction, right? They seem to be doing something different. And so if these are our guiding precedents, do we think the federal government's still allowed to regulate this or not? I want one more stab, at least one more stab at, you are the lawyer for the person arrested for private, non-commercial possession of one marijuana plant that is producing a modest amount of the illegal drug that you are planning to use privately in your own home. Does this matter on doctor's orders, right, for medicinal purposes that has been lawfully authorized by your state government, right, which many states have done? You're not selling it. You're not taking it across state lines. Yeah.
I guess you could argue that they possibly bought like the seeds to grow the plant from some supplier across state lines.
It's possible. So you're still on the other side, right? So I want somebody to defend the marijuana possessor, but yes, right. Congress for sure would say, okay, well, wait a minute, is this completely really just in one state or not? Right? Where did she get the seeds? Right? But it is possible, right, that somebody could, a friend who lives in the same state, who had a plant, removed some seeds from his plant and gave them to you. It's neither interstate nor commercial, right? You didn't buy them and they didn't cross state lines. That's possible, right? Obviously, the facts would be different in different cases. Let me frame this question slightly differently. In Lopez and Morrison, both of which are 5-4 decisions, this is a little bit of an oversimplification, but we know that it is sometimes true. It's the court's 5 more conservative justices who are in the majority. And it's the 4 more liberal justices who are in dissent. What would we expect those justices to do in our marijuana case? How do we think it would come out? Right? After Lopez and Morrison, similar case, but about private non-commercial marijuana possession. Would it come out the same way or differently? And why? Okay.
I think it has to deal with more than just interstate commerce, and so on those grounds, I think that they could escape like contradicting themselves on Lopez and Morrison and still like enforce a regulation on marijuana at the federal level.
So let me just make sure I understand. So the justices in the majority in Lopez and Morrison who held that we should restrict Congress's power in these cases, that they could allow Congress's power in this other case, and it would not be a contradiction because
they rely on more than the interstate commerce clause, or I would think they would, because there's more than just a commercial interest that they're trying to protect.
Well,
Also,
what else
violence
is there?
that is related to like the transfer of drugs. And
okay, but remember in both Lopez and Morrison, the court says criminal law is historically the province of the states, and obviously we do have some federal criminal law now, but that should be the exception rather than the rule. For sure, if there's international drug cartels that are engaging in violence, like across the whole country, like, yeah, the Congress is going to be able to regulate them.
Can it be like necessary and proper to protecting public health?
It could be, but what in the Constitution leads us to believe that the federal government has substantial authority to regulate public health? Right? Remember, the language of the necessary and proper clause is all other powers vested by this Constitution. Oh no, sorry, started before that. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States. So necessary and proper is like half of an argument, because you still have to finish that sentence, right? Necessary and proper to do what that Congress is allowed to do. So like in the National Bank case, Chief Justice Marshall, he spent most of his time on necessary and proper, and he had a long debate about what the word necessary means and how strictly that should be read. But he listed a bunch of other powers of Congress too, right? And so he said, Congress has the power to regulate interstate commerce, Congress has the power to coin money, Congress has the power to raise an army and navy. Congress is telling us that all of those things will be easier to do, right? It's going to be easier to pay the soldiers if we have a national bank with branches in every state, right? And so it's necessary and proper to doing these other things that Congress is allowed to do.
I just want to add on to that because I think I got what she's saying. Necessary and proper to provide for the general welfare.
Okay, so that's good. So the first, Article 1, Section 8 is a long list of things. I just pulled out some key parts of it on this quote on the handout. So this is the one we haven't talked about yet. Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. Sometimes that provision is read as a really broad grant of power to the federal government. Federal government's allowed to do whatever it thinks is necessary and proper to promote the general welfare of the United States. That seems consistent with the words there. But if you read it that way, then I'm pretty sure Congress can regulate rape and sexual assault throughout the country, and I'm pretty sure Congress can regulate the possession of guns in schools. Like, doesn't Congress think that's necessary to the general welfare of the United States? The Supreme Court in those cases is like, no, that is too broad of a reading. Because if you read it that way, It means Congress can do anything that it wants. For example, it means that Congress is asserting a general federal police power. In 19th century lawyer lingo, the police power means the power to pass laws to promote the public health, public safety, and public morals, which is a power that the federal government does not have in the 19th century. Right? The states have the police powers. Right? If you are just trying to protect the public health, that is the state's job in the 19th century. Right? Cases like Wickard and the cases about the 64 Civil Rights Act seem to suggest, although they never quite all the way say this, they seem to suggest that there is some pretty broad police powers in the federal government too. Right? And so a law to promote the general welfare, a law to protect and promote the public health, right, that had some kind of connection to national level problems, right, would be within Congress's powers. In Lopez and Morrison, the court says that goes too far. That is inconsistent with the original understanding of our Constitution, and so we need to cut it back somehow. Right? And laws that are just designed to protect the public safety or the public health that don't have any connection to interstate commerce or any really direct and close connection, those ones Congress is not allowed to pass. Right? And so the question about what would our justices do in this case is a question in part about, do we think that the justices will consistently adhere to the constitutional principles that they spell out in one case? Would we expect them to consistently adhere to those principles in a different case where the political implications seem reversed? Right? If you are Justice Clarence Thomas or Justice Antonin Scalia, you might strike down the Gun-Free School Zones Act because you think Congress is overstepping the bounds of its power under our original constitutional system of federalism. You might also strike it down because you are not a big fan of gun regulations. But then if the marijuana laws come to the court with basically the same constitutional argument, would we expect them to stick to the same constitutional principles, or would we expect them to waffle and say, oh, well, yeah, but of course Congress can still outlaw illegal narcotics? That's totally different for some reason that we'll figure out what to say about, right? So this case does come to the court, and the answer is that many of the justices are consistent, and some of them are not, right? California authorized the lawful medicinal use of marijuana with a doctor's prescription. A woman named Angel Raish had 2 plants growing in her closet that were given to her by a friend for her own personal consumption on the recommendation of her doctor. I believe she had late-stage cancer. There's a variety of health conditions for which there's substantial evidence that marijuana use can provide some important medical benefits. But marijuana possession is still illegal under federal law, and she was charged with violating the federal law. And her lawyer, she got a famous libertarian lawyer to help take her case. He's a law professor at Georgetown now. His name's Randy Barnett. And he was like, yeah, we got Lopez, we got Morrison, we got these great recent cases. I think we can win this, right? There is no constitutional authority for Congress to regulate the private, non-commercial, local possession of marijuana. But they lost in the Supreme Court. The Supreme Court upheld that law. And some of the justices were consistent, right? The 4 justices who were in dissent in Lopez and Morrison said, no, we should keep reading federal powers broadly, just like in Wickard, right? Substantial effect on interstate commerce, then yes, Congress can regulate it. Does the private, non-commercial possession of marijuana by people like Angel Race aggregated together with all people in similar situations, does that substantially affect interstate commerce? Clearly, yes. This case is very much like Wickard versus Filburn. We rule in favor of the federal law, right? So those 4 justices supported a broad federal power in all the cases. Justice Thomas, Justice O'Connor, Clarence Thomas, Sandra Day O'Connor, and Chief Justice Rehnquist supported narrow federal power in all 3 cases. Right? Justice Clarence Thomas wrote an opinion, dissenting opinion, saying Congress has no authority to regulate this woman's possession of marijuana. That is not, I don't think, because Clarence Thomas is like a big fan of homegrown weed, right? That is not why he's ruling that direction, right? That is not what's going on. He is saying there is a constitutional principle about the original understanding of the limits of federal power that is violated by this application of the law. And just like I didn't want us to do it with the Gun-Free School Zones law or the Violence Against Women Act, I don't think Congress can do it in this case either. But the case comes out the other way because 2 of the justices switch. Justice Scalia and Justice Kennedy. Justice Scalia and Kennedy are in the majority for narrow understandings of federal power in Lopez and Morrison, and they are in the majority for a broad understanding of federal power in Gonzalez versus Raich. And so there's 2 possibilities. Possibility number 1 is they don't really mean it when they say that there's some constitutional principle. They don't stick to that, right? They stick to it when it's convenient for them, and they don't stick to it when it points in a direction that they don't like. That is one possibility. A second possibility is, like lawyers are good at finding distinctions, and maybe there's some details about the specific nature of this regulation as applies to this specific person that work out differently in some ways than the gun law, and you can draw some lawyerly distinctions. Maybe this is even a third possibility. Could be 2B or it could be 3. Third possibility for Scalia and Kennedy is that, well, we meant it when we said it in 1995 and 2000, but on reflection, we think that maybe we were rash and we need to pull back a little bit. The language in our opinions in those 2 earlier cases seems to suggest that there are a whole lot of federal laws that would be unconstitutional and we would now be required to strike down, including, somebody has just called our attention to the marijuana laws. If we stick with that principle, I think we got to strike down the marijuana laws in part. That does not seem right. And so maybe on reflection, we are reconsidering those constitutional principles that we articulated a few years ago, and we are going to try to roll them back a little bit. And if you read Scalia's opinion, Justice Stevens writes the majority opinion, but Scalia writes a concurring opinion in Gonzalez versus Raich. And if you read it, it's quite broadly supportive of federal power. Right? Quite broadly supportive. Right? Lopez, Morrison, we said we got to draw some lines, but Wickard is still on the books. We haven't gotten rid of that. I still basically agree with this, right? If Congress is regulating some important national problem that is clearly national in scope, then Congress has the right to extend that regulation into all the different parts of the country, even to people who seem pretty far afield. Just like we said in the civil rights cases, right? Even the local barbecue joint can be prevented from discriminating on the basis of race, even if they're not engaged in very much interstate commerce. They're pretty loosely connected to it. Still, that's fine. Scalia says all that in his concurring opinion in Gonzalez versus Raich. All of these opinions are really important for thinking through what the Supreme Court should do with the Affordable Care Act, right, which comes later. One other case I want to throw at you, which is also important for thinking about what the court's going to do with the Affordable Care Act, is about a different provision in Article 1. So, the one we were just looking at. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States. That phrase is sometimes called the spending clause, even though the word spending is not in it. Why is it called the spending clause? Yeah.
Because you spend money to provide.
Yeah, that seems to be what it's saying, right? The federal government has the authority to spend money to provide for the common defense and general welfare, right? So one of the things that we know Congress is allowed to do is appropriate federal funds, right? And it comes right after the part about taxing, right? Congress is allowed to raise taxes in order to provide revenue for the federal government, and it is allowed to spend that money for what purpose? To provide for the common defense and general welfare of the United States. That's one of the main things Congress does. And so it's called the spending clause. So basically, it seems like a broad grant of power to Congress to decide what to spend federal money on. Periodically, Congress has passed laws that authorize federal government expenditures with some condition. Right? I mean, any federal expenditure has some condition on it, probably. Right? If we say, here's some money to build a federal highway, probably they stick some stuff in there about, like, the Department of Transportation is going to adopt regulations to make sure we're only hiring qualified contractors. Don't give the money just to your friends. Got to be some kind of competitive bidding process. Right? Probably every governmental expenditure has some conditions attached to it. Sometimes those conditions do something a little different or go a little further. They say, here's a new federal policy, here's the money we're authorizing to be spent on it. It's going to happen all throughout the country in different localities. In any particular state which does or doesn't do something that we want them or don't want them to do, right, they get extra money or they get less money. Right? For example, Congress passes a law authorizing the expenditure of federal highway funds, right, to build new federal highways and maintain existing federal highways, X amount of millions of dollars appropriated for the next coming year. The Secretary of Transportation is authorized to withhold 10% of those funds that are allocated from any given state if that state has a drinking age that is less than 21. At the time Congress passed that law, about 30 states, 31 I think, had drinking ages less than 21. Congress had done this with other things too. Earlier, Congress had passed one that said we're going to withhold a certain percentage of highway funds if the states have a maximum speed limit higher than 70 or something. I forget what it was. We're going to try to incentivize states to reduce their speed limit. And the logic of both of these is the same, right? There's substantial evidence that reducing the speed limit and raising the drinking age reduces the incidence of highway accidents, fatalities, injuries, and the like, right? Less drunk driving, less fast driving, more highway safety. And so we're spending federal money to build highways in all 50 states, build and maintain highways in all 50 states. States are going to lose a little bit of their money, 10%, if they don't modify their drinking ages or their speed limits or whatever it is Congress is focused on at the moment. Any constitutional problem with that?
You're using expenditure to essentially pass a law you may not otherwise have the authority to pass.
So that's the trick, right? Why doesn't Congress just pass a law that says the nationwide drinking age is 21? That would seem more straightforward. Congress does not have the authority to do that, right? The regulation of alcohol possession and consumption historically has been considered part of the police powers, and in fact there is a provision of the Constitution, remember Prohibition, which is the 18th Amendment, and then was repealed by the 21st Amendment. The 21st Amendment, which is still in the Constitution, says, oh yeah, that earlier one, we get rid of that, and henceforward it says something like, states have the authority to regulate alcohol possession, and it says, oh, it does say something about the federal government. It says the federal government can regulate the unlawful interstate transportation of alcohol into a state where it would violate that state's laws or something. So it basically says states could still have prohibition if they wanted, right? States get to regulate it, right? So the regulation of alcohol consumption and possession is basically a state matter. And so Congress presumably does not have the constitutional authority to directly enact a nationwide minimum drinking age. And so it sort of looks like Congress is trying to backdoor, right, trying indirectly exercise a power that it doesn't have. On the other hand, it's federal money, which Congress is fully entitled to spend, right? The state of New York doesn't get to tell Congress how their federal money is spent, right? It's totally up to Congress. Congress could say, we're not spending any money on highways this year, if it wanted. So why couldn't Congress put some conditions on the expenditure of federal funds? This particular law gets challenged in the Supreme Court in a case called South Dakota versus Dole in 1987, and the Supreme Court upholds the law. Right? Supreme Court says general welfare clause is pretty broad. It says Congress has the power to spend money in pursuit of the general welfare. Right? Congress has always attached conditions of various kinds to that money. So long as there is some kind of connection between the condition and the expenditure, like maybe we would look at it differently if the law was like, your state loses its highway funds if it doesn't regulate abortion the way we want to, or something. Like, what the heck is that connection? Like, as long as there is some connection between the condition and the expenditure, and there clearly is a connection between drinking age and highway fatalities, so long as there is some connection, we think Congress is free to do this. 2 justices dissented. It was 7-2. And 2 justices were like, I don't know. I know Congress has been doing this for a long time. We've never struck down a law on these grounds before. But it seems to me that Congress is trying to indirectly exercise a power that lawfully belongs to the states. Congress is trying to subvert, to get around a constitutional limitation on its own power. And we think that violates the constitutional structure of federalism. 2 justices say that in South Dakota versus Dole. That issue comes back up in the Affordable Care Act case, too. So we'll look at that next week. That's all. If you weren't here last time, I got some papers.